Okay, so when I started thinking about this session and what it means to talk about the rule of law, what it means to talk about the rule of law in times of crisis, it seems to me that there are basically three distinct questions that can actually guide this discussion. The first one is, I think, a little bit underrated in part of the literature, not in all of the literature, but in part of the literature. And that's the question of what we mean by the rule of law, right? What we understand by the rule of law. And here I'm reminded by something that the late, well, now late, Joseph Raz said about the rule of law. He said that if a concept is the property of lawyers, politicians, ordinary people, professionals in different disciplines, then it is inevitable that you will end up with as many different conceptions and understandings of the rule of law, contributing to this sort of indeterminacy, we might say, flexibility, some others might say. So I think it would be interesting to begin by thinking a little bit about what we understand by the rule of law, how we could group different ways of talking about the rule of law. And the second question is, I think, that the one that is probably most prominent in European studies today. And that has to do with the rule of law in times of crisis. Within the European Union today, and this was evident in Dimitris' earlier lecture, there's this huge discussion and debate about the rule of law as a core value of the European Union. And there's discussion about, okay, what do we do about the rule of law? What's wrong with the rule of law? How is the rule of law threatened today? We have discussions about populism in different countries and so forth. So I think it would be interesting to also talk about the state of the rule of law in such times of crisis. And then the final point related to that is, if we do accept that there's something threatening the rule of law, if we accept that there's something at stake, then what can we do to protect the rule of law? And of course, that question can be asked on at least two different levels within the European Union. First, we have the national level. So what can we do domestically to protect and safeguard the rule of law? And then, of course, at the European level. So what can the European Union do, or what does the European Union do to safeguard the rule of law, if indeed the rule of law is threatened? So I suggest that we approach this discussion from that angle. And so I suggest we start by thinking of what we mean by the rule of law. And here I invite you to think of it in this way. Think of a rule of law country, and then think of whether that rule of law country would continue to be a rule of law country, barring one of these multiple considerations. So let's take the first component that I have here on the list. Incidentally, this list is just an indication, right? I'm not claiming that these ideas exhaust the rule of law. It's just, you know, a checklist of different elements that have conventionally been associated with the rule of law. So think of the first one, that the law must be general, so no ad hoc legal pronouncements. Can we think of a country that we would call a rule of law country without that component? I think that's probably difficult, right? We tend to think that generality of rules is one of the very core elements, the characteristics of the rule of law. A rule of law country is one where rules are general. It's not that a ruler can create a new law ad hoc targeting you because they don't like you, for instance. And along the same lines, we could think of different components that are typically associated with the rule of law. That the law must be prospective, that the law must be clear, that all disputes about the law should be decided by an independent and impartial judiciary. So I trust, and I think most of you would probably agree with this, that there are some things that we just associate, perhaps uncritically, with the rule of law. That they are always components of the rule of law. And then we probably move to some other elements that are a little bit more controversial. For instance, if I told you that there's a country where there's no separation of powers, would that be a rule of law country? Some of you might say, no, it cannot be a rule of law country without the separation of powers. Some others might say, well, what does separation of powers have to do with the rule of law? If the rule of law is simply about creating law through a specific way, through certain procedures, and if it's just about the law having certain characteristics, being clear, being prospective, not asking the impossible, and so forth, then maybe we would say that separation of powers is not an element of the rule of law. And then we can think of further, more complex elements that are typically invoked when it comes to the rule of law. For instance, what about the country in question enacting legislation that is against human rights? Would you say that this country is a rule of law country? Some might say, well, of course, how can you have the rule of law if the law does not respect human dignity and consistently violates human rights and so forth? And then others would say, oh, hold on a minute, these are two different questions. The rule of law is just about one thing, and then there's another discussion about human rights, and then maybe there's another discussion about democracy, and maybe there's another discussion about all sorts of different concepts. So what I'm trying to get at here is that there's much complexity about the rule of law, precisely because we tend to associate many different things with the rule of law, perhaps in different contexts, and because we often mix the rule of law with other political ideas, as Joseph Raz would say. And we mix the rule of law with democracy, for instance, or we mix the rule of law with human rights. So in the literature, there are certain divisions between theorists, between people who talk about the rule of law or theorize the rule of law. Some of them adopt a much narrow approach to the rule of law. They think of the rule of law simply in terms of certain procedural characteristics or maybe formal characteristics. And here I have a checklist that was provided by the American philosopher Lon Fuller back in 1964 in his book, The Morality of Law. And what Fuller is suggesting in this checklist, incidentally, Fuller does not necessarily espouse a thin conception of the rule of law, but his checklist is associated with that conception, that narrow conception of the rule of law. So what Fuller is saying is that there are certain elements that must always be here if we are to have a legal system. So if you have a system that always creates retroactive legislation, for instance, then it's not a legal system at all. And so this checklist is often associated with this thin conception of the rule of law. So the first thing that I would like to discuss is essentially to what extent do you think, here in the room or in the chat, that this thin approach is a useful tool to talk about the rule of law, to discuss the rule of law. Because I would like to draw a connection here with Dimitri's earlier discussion, earlier speech about the approach of the Court of Justice. So is there anyone who'd like to make a comment at this stage or ask a question or offer any insight?
Andreas, I can offer an insight if you'd like. It's Kliakos Kyriagidis.
Hi, Claire. Well, thanks for dropping in.
I'd just like to, first of all, thank you for your analysis, but my comment regards the question you put as to whether the rule of law can exist in isolation of democracy. If one reads the analysis of the rule of law by Lord Bingham, who adopts, of course, a very British approach to the rule of law, one finds no overt or express reference to democracy in either his definition of the core of the principle or in any of the 8 sub-rules that he puts forward in order to give flesh to the idea of the rule of law. So on the face of it, from the perspective of Lord Bingham, whose approach has now been widely accepted as being perhaps the best of the British or the modern British approaches to the rule of law, there is no overt reference to democracy. That being said, democracy is surely implicit in at least one of the 8 sub-rules, namely the sub-rule that supports human rights. Under the European Convention on Human Rights, the idea of a democratic society is built in to the convention regime that is established by the convention. So I would, if one adopts Lord Bingham's approach, which to a great extent I do, I would suggest that democracy and the rule of law go hand in hand. I'll just make one second point relating to that. In antiquity, in ancient Athens, and Lord Neuberger, when he was Master of the Rolls, he gave a lecture where he made this point, that in ancient Athens, the rule of law, or rule by law perhaps, was laid down before the emergence of the ancient or the limited ancient and Athenian version of democracy. And that suggests that for there to be democracy in existence, there needs to be the rule by law. And what democracy does, it humanizes rule by law, and it turns it into the rule of law. So that's my little contribution to your analysis in response to your very pertinent and indeed very significant question.
Thank you very much, Claire. I do have a question to you, however, because in your discussion, you said that in Lord Bingham's work, you find democracy implicit in human rights. And as you're going to see in one of the later slides that I have here, you're absolutely right that Bingham offers an account of the rule of law that is intrinsically connected to human rights. But what I'd like to challenge here is this association you draw between human rights and democracy. Because perhaps we can think of human rights being conceptually distinct from democracy. So in that sense, let me propose a hypothetical, right? And maybe, of course, you disagree with that. Think in state A, we have a democracy, an ordinary democracy. And that democracy works with the limitations that democracies ordinarily do. That is disagreements and conflict in discussion for the creation of law. And in that democracy, we have a certain respect and protection of human rights. Not absolute, certainly not horrible, but maybe down the line. And I think you might quite plausibly think that, okay, this reflects many of the ordinary democracies we have here. And now in this hypothetical that I'm proposing, again, hypothetical, we have a person, the so-called benevolent dictator. One person in charge, but that person is an extremely good person. That person creates, enacts, and maintains a robust system of human rights. On that hypothetical, the human rights protection of the second state would be wider than those of the first state, because the first state is limited by certain democratic constraints, whereas in the second case, no such democratic constraints. Now, of course, you might come back to me and tell me there's no such monarchy in place, and therefore there's a contingent connection, a historical connection between democracy and human rights. I don't doubt that, so I don't disagree with that. But what my hypothetical example purports to show is that there's no necessary theoretical connection between human rights and democracy. So we can think of human rights without thinking about democracy. Depending on your definition of democracy, you might not be able to think of democracy without human rights, but that's a different question. So clearly, that's kind of my response to your attempt to draw in Lord Bingham in that respect. Although I do agree with you, Lord Bingham does talk about human rights, and I also agree with you that he does implicitly talk about democracy. It's just that from an analytical standpoint, there's no necessary connection here, or at least that's what I think.
Can I come back on you?
Of course.
Thank you for your insights. I suspect Lord Bingham deliberately omitted any express reference to democracy in his core definition and in the 8 sub-rules. He no doubt was trying to influence developments in ostensibly undemocratic regimes with a view to nudging them in the direction of human rights. And therefore he put in the human rights, but without expressly linking human rights to democracy. And to that extent, Lord Bingham's approach is indeed commendable, because one of the challenges that we face in the world today is to persuade autocratic regimes to humanize themselves. But perhaps the other point that I would make in response to your comments is that I cannot think of an autocracy where freedom of expression, or as we say in common law, freedom of speech, takes pride of place in the political culture. And given the criticality of freedom of expression to human rights, that underlines my argument, which you can of course question, that human rights and democracy must go hand in hand if they are to mean anything. Now, democracy, of course, doesn't mean rule by the majority at the expense of the minority, nor does it mean oppression of any part of society or any individual human being as a result of an electoral mandate. But democracy and human rights, as I see it, go hand in hand. You can't have one without the other.
Thanks very much, clearly. I would say, as a response to that, that at least depending on the conception of democracy you adopt, you might say that free speech is distinct from other human rights because free speech is the quintessential democratic element. Right? So one of the things that my supervisor, Eric Hines, suggests is that free speech is conceptually different from other human rights. That's why his latest book is called The Most Human Right, because it's different from other human rights for the reason that it is the necessary component of democracy. But of course, I do accept your point. I do understand where you're coming from. And in fact, this leads to the next point that I wanted to make. Okay, there was something I wanted to say about thin conceptions, but it leads to the other point that I wanted to make in terms of approaching the rule of law from a different perspective. Because what you've pointed towards in mentioning Lord Bingham is that we can move beyond this sort of thin conception of the rule of law. We don't necessarily need to think of rule of law simply in terms of procedural guarantees or the form that law has to take. Instead, we can add substantive components, substantive elements. And Lord Bingham, of course, provides the quintessential thick conception of the rule of law, revolving around human rights. And this is actually a quote from Lord Bingham, where Lord Bingham is saying, although I recognize the logical potency, power of Professor Raz's argument about the thin conception of the rule of law, he instead opts for, quote here, a thick conception, a thick definition, excuse me, embracing the protection of human rights within its scope. A state which savagely represses or persecutes sections of its people cannot, in my view, be regarded as observing the rule of law, even if the transport of the persecuted minority to the concentration camp or the compulsory exposure of female children on the mountainside is the subject of detailed laws duly enacted and scrupulously observed. So here, I think, Claire, this was the point you were trying to make earlier, that simply adopting the formal conception of the rule of law, simply saying that, oh, rules must be prospective and clear and certain and understandable to everyone and not asking the impossible and so forth, that we are okay on the rule of law front. Instead, what Lord Bingham is suggesting is that you cannot talk about the rule of law without talking about human rights. And Claire, I think that was exactly the point you made earlier, right?
Yes, I mean, if I can just make one final intervention here in closing our very fruitful Socratic dialogue. The English phrase, the rule of law, is in itself problematical. When he was Master of the Rolls, Lord Neuberger gave at least one lecture where he used the phrase the rule of just law in order to put forward what amounted to back then the Lord Bingham, a thick approach to the rule of law. I actually do like that phrase, the rule of just law. In a way, it's closer to the phrase that's used in Greek to describe the rule of law, to grados δικαίου. Δικαίου being a word, correct me if I'm wrong, because your Greek's better than mine. Δικαίου being a word that means law, but it also, in a sense, is connected to justice. So perhaps as the way for us to avoid this confusion between rule by law on the one hand, rule of law on the other, is to sort of tweak the phrase the rule of law and to adopt Lord Bingham's approach by referring to the rule of just law. But of course, this is where you will come back and counter argue. The phrase the rule of just law takes us towards justice, whatever justice means, rather than towards democracy. But then again, I would suggest that justice and democracy and human rights all go hand in hand. So this is the problem with Socratic dialogues, Andreas. They can go on forever. So I will draw a line under it here, unless you want me to come back in.
Don't, because that's kind of the point of the roundtable. And now Stephanie has an intervention, so please.
Yes, thank you very much. No, I think this is great discussion. Thank you, Claire, for joining us. I wanted to reinforce that point because it struck me across the final conference yesterday and today how important is the linguistic and the epistemology of words as well. So here is another example. If you take the expression or the concept in French, where you're actually even closer to what Claire was describing than in Greek, because in French, l'état de droit, droit means law, but it also means that something that is fair, just, right to the point. Yes, so we have the exact notion of the word that we are looking for, this double notion of the word. And it's true that for a continental person, to appreciate the understanding of the rule of law in English law or on the common law context and in the English language is a struggle.
Also in German law.
Yes, Rechtsstaat. It's the same, Rechtsstaat.
So I do agree with this, although this is also something that Raz talks extensively about, because Claire, if we accept the point that, okay, now we're talking about the rule of good law or the rule of just law, then immediately that presupposes a complete political, moral background against you can define what good is and what justice is. Which for Raz, again, it's not that I necessarily agree with what Raz has to say, is that he's making some good points that should cause us pause and cause us to think a little bit about this question. Because if you talk about the rule of law, I agree with you that we should have in mind that maybe we should distinguish it from the rule of good law, in the sense that the first one might indeed be a more neutral element compared to the second one. And it's here that what Raz is saying is that, oh, we should opt for the first one when we talk about the rule of law, because it is about the formalities of law, about the form of the law, not about the substance of the law. And we should leave the second question, that of the rule of good law, to discussions of political philosophy, for instance. So we shouldn't confuse the two. That's what Raz would say. I'm not necessarily saying that this is how we should approach the rule of law. What I'm suggesting is that it's important we have this distinction in the background when we think of the rule of law and when we talk about the rule of law. And incidentally, Kleanthos did bring up this idea of the rule of law and human rights being connected, but one could also draw almost as clear a connection between the rule of law and democracy, arguably clearer connection. So without talking about human rights, connect the rule of law and democracy. Now I have to say from the outset that this is the approach that I tend to favor. This is the approach that I think makes most sense. And I think we can trace this approach to Aristotle. And here I actually have a quote from the Politics. And it goes as follows. It is just for them, that is, people who are equal, to rule no more than they are ruled, and therefore to do so in turn. But this is already law, for the organization is law. This is more, thus, it is more choice-worthy to have law rule than any one of the citizens. And even if it is better to have certain people rule, they should be selected as guardians of and assistants to the law. Anyone who instructs the law to rule would seem to be asking God and the understanding alone to rule, whereas someone who asks a human being asks a wild beast as well. So this is probably the earliest defense of the rule of law that we can find in Western theory. And I think that there are some elements that are quite interesting here. First, let me dispose of the religious component. When Aristotle talks about God, he is certainly not talking about the Judeo-Christian God. He's not even talking about ancient Greek gods of the pantheon, right? So here, God is essentially, for Aristotle, logos, the personification of reason, of rationality. So what he's doing here is he's associating the rule of law with the rule of rationality and distinguishing it from the rule of human beings. Now, someone might plausibly ask, aren't we all ruled by human beings? It's human beings that make rules. It's human beings in parliaments. It's human beings enforcing the rules. It's human beings deciding if a law is broken and so forth. But of course, when he talks about asking a human being to rule, what he means is asking a human being to rule on his discretion, right? Arbitrarily, without guidance, according to their own whim, according to their own judgment. So what Aristotle is suggesting is that the rule of law has a kind of wisdom and rationality that is lacking in human beings, and that the rule of law should therefore have priority when it comes to the regulation of political power, how we are to be ruled. So from this, one might wonder, well, what is the connection with democracy? And the connection, I mean, assuming you're familiar with Aristotle, should be quite apparent in the third book of the Politics, when he talks extensively about the rule of the many compared to the rule of the few, because for Aristotle, the essence of reason, the essence of rationality comes in collective deliberation. So you can only achieve rationality through actual discussion with other people. And here there's a point in ancient Greek where the word logos means both rationality, reason, and speech. Right? So it's through speech that you manage to get to reason. And of course, this reinforced the earlier point I made about free speech being connected with democracy. So to summarize these different approaches, so that everyone is on the same page, we can first think of a thin conception of the rule of law, which is essentially a series of formal characteristics, a formal requirements that the law should have if it is to rule. And for Hart, that approach to the rule of law tells us nothing about substantive justice or injustice. And as he puts it, those principles of legality identified here are compatible with great many inequity, with much injustice. So you could have a system that creates general legislation, but also perpetrates the worst of crimes. Compared to that thin approach to the rule of law, we could think of more substantive approaches to the rule of law. The first one might be in terms of democracy, where the rule of law is tightly connected and associated with democracy. The next one might be with human rights, where the rule of law is tightly associated with human rights, meaning that you cannot have a system of the rule of law without human rights. And this, leads me to kind of a summary of what the main problem might be. Because the main problem of the rule of law is that due to those different conceptions of the rule of law that we've identified, in different contexts, different actors, legal actors, political actors, non-political actors, right? So people not acting in the political stage, might be using or relying on a different conception of the rule of law. And as an example for that, I'd like to bring the European Union. Because I think this is an area where this becomes a little bit more explicit. Dimitri mentioned earlier the Court of Justice, and traditionally, the Court of Justice relies on a specific understanding of the rule of law centered around judges. So when the Court of Justice talks about the rule of law, in most cases, they primarily talk about judicial independence and the independence of the judiciary, impartiality of the judiciary, and so forth. So, excuse me, that might be one approach to the rule of law. When the Court of Justice talks about the rule of law, they don't necessarily, and of course, Dimitri, you're welcome to correct me or point out anything wrong with what I'm suggesting here. They don't primarily talk about democracy. They don't primarily talk about human rights. They might put them together, talk about the rule of law and democracy and human rights as values. But when they rely on a kind of definition of the rule of law, it is in most cases a little bit more limited. And this compares to the approach of other institutions. For example, the European Commission, in its annual rule of law report, they adopt a broader understanding of the rule of law. In fact, one of the 4 pillars that they actually investigate is media pluralism, the free speech of media, which of course we could associate with democracy or with human rights. So what I'm trying to suggest here is that in different contexts, different actors for different reasons might be relying on different understandings of the rule of law, on different conceptions of the rule of law, and this might contribute to the difficulty that anyone might have following those different arguments, precisely because they rely on a different theoretical background. Is there anyone who'd like to comment on this, or maybe criticize what I've suggested, or disagree with it? No? Silence? No? Okay. Okay, that's fine. So the next point that I am proposing here is about thinking of the rule of law in terms of emergencies. And this was primarily prompted by the COVID-19 emergency. For the following reason. If we think back to the quote by Aristotle and his dismissal of the rule of human beings, as I suggested earlier, this was a dismissal of the arbitrariness of the discretion of human beings. It was a dismissal of human beings making decisions ad hoc, whimsically, haphazardly, whatever adverb you'd like to insert. At the same time, Aristotle recognized a point that Plato made before him, that, you know what, at times, you kind of want that ad hoc, discretionary, arbitrary action. Of course, in the ancient Greek context, that was put in terms of the military, right? And the discussion there was, okay, when we are at war, we don't want democracy, we don't want the rule of law, we just want a competent general that is going to guide us to victory. Someone to make decisions arguably unbound by the ordinary rules, although of course that wasn't always the case, as the trial of the generals of Arginusa teaches us, where military leaders were put on trial for their misconduct on the battlefield. But this is a different question. So Aristotle does agree that we might have a reason for accepting this sort of non-rule-bound behavior. And in the COVID emergency, we saw something along those lines. Once COVID hit and once COVID was declared a pandemic, what we had was a slew of executive actions, emergency actions, actions that did not follow the ordinary legislative procedures, actions that did not go through the parliament, for instance, actions that were often unclear, actions that were often against basic principles of proportionality and so forth. And so during the emergency, there was this renewed discussion about the rule of law in times of emergency. So the next point that I'd like to raise, and I'd like to ask you maybe if anyone has an insight or something that they'd like to propose, is to what extent those emergencies represent a break from the rule of law, and to what extent can the rule of law be seen as compatible with those emergency measures. It's a question, yes. So I think it's essentially a very basic question, right? When we have those emergency measures, is it something that you think is subject to the rule of law, or something that is clearly kind of a legal bracket, let's say, a legal bubble, a legalistic bubble, something that is exempt from the ordinary functioning of the rule of law? That's essentially the question I'm posing.
But
I think it'd be better if you come a little bit closer so that people can hear a voice other than mine.
So and I think this comes to my issue with the concept of the rule of law altogether, because my brain is quite foggy on on discussions on emergencies a bit more broadly, and you yourself mentioned, and I didn't know, that in classical Athens, the military was the exception to the rule of law, because a war, when we talk about emergencies in international law, we know that by default, by its very existence, a war is an emergency situation where some normal applications of the law get suspended. So I am not sure whether I'm making sense, because my brain is full of that at the moment. But and it always comes down to, for me, whether it is the war or the pandemic, it doesn't really matter, as long as you have a situation that is outside of the ordinary, right? So the problem is that we have all these rules on how to apply emergencies, but there is always people there who take advantage of that power. It is, I think we have, especially, I'm trying to think whether I can generalize here, but we have too many examples for us to be optimists of situations where those emergency rules were not applied according to what was the established rule on how to apply emergency laws, emergency powers.
You think that was a good thing?
No, I think that is a bad thing.
Okay.
But the way we talk and we think about rule of law and emergencies, it's failing in practice. It's not failing to take it into account. I think we are still struggling with the mechanism, or whatever it is, the criticisms that is going to make this relevant in practice. Like, we have these theoretical discussions, and I am not a theorist in any way, but we also have all these practical examples and problems.
So, okay.
And the two are still to meet even closely, I think.
So before we turn to Katerina's, because she has raised her hand, let me see if I understand what you've mentioned. You've said that we do have a system of rules designed to accommodate emergency circumstances.
Very often we do, yes.
Very often we do. And yet, when it comes down to the application, what is being applied is not what was legally provided.
Not necessarily.
Not necessarily what was legally provided. So the question in that case is, would that action be ultra vires? So would it be an action that it would be reviewable by a court, for instance? Or is it an action that represents a break from the rule of law, the system of legality? Because I think is the key question, right? Because I think you very correctly pointed out that, even in emergencies, we have the rule of law because we have a legal framework of dealing with emergencies. But then the actual question is, if it's a system that is supposed to deal with emergencies, but it's never used, then what's the point of it, right? So if emergency actions are not pursuant to that legal framework, they are either illegal or they are not. If they're not, it means that the legal framework is non-existent, doesn't work, there's no point to it.
Yeah.
You understand what I'm trying to say?
Yes.
So what do you think it is? Is it the second one, that we actually don't have a legal framework capable of dealing with emergencies? Or is it a problem of, corruption or misunderstanding of the law, or not caring about the law? Or is it a question of not caring about obeying the law?
I would say the second one in that regard. It is a question of political interest determining how we react to emergencies rather than the law determining how we react to emergencies.
Fair enough. Fair enough. Katerina?
Hi everyone. Let me try and switch on my camera as well. Can you hear me?
Yes, we can.
Okay, perfect. So I just wanted to add something based on what you and Nadia have been discussing. I mean, obviously, I'm not an expert in international law, so I cannot really reply to the war exception that Nadia mentioned. But I guess because I've been working with crisis for some time now, not in the sphere of the rule of law, and but in terms of EU citizenship and fundamental rights. And I guess emergencies usually, or at least most of the times, are the routes through which either fundamental rights or EU citizenship for COVID have been violated in a way, or have been suspended in a way, and has been justified, either because of the financial crisis, either because of COVID restrictions and so on. For the rule of law, I think it's a very particular case. I think this is what makes the rule of law a separated concept from the rest of the European values. Because the rule of law, if it suspends or if it is violated in a way, it affects everything else. What I'm trying to say is that whether a value, can you mute your microphone, because I can hear my voice. Thank you. So what I'm trying to say is that I guess emergencies are used a lot to justify restrictions of European values, but some European values, like the rule of law, should not be limited in any way, because then it affects the whole idea of the law and the whole idea of having exceptions and rules and everything else. And this is maybe why the rule of law should be differentiated from the rest and put in a different position from the rest. So when it comes to your question, I think the rule of law should not be suspended, or emergency should not justify any such suspension. And the reason why, it's because I think it should be put in a different, let's say, box than the rest of the European values. And I think this is what we discussed together before on how we define the rule of law in terms of EU law.
Yeah, and as you can suspect, I agree with that approach, because I do think that the rule of law is not necessarily against discretionary power, right? So I think you could plausibly and conceptually have a system of the rule of law that provides, under clearly defined circumstances, limited circumstances, that's another key point here, some additional executive power, for instance. What's important, however, and this is the point that I raised to Nadia earlier, is that as long as you maintain some accountability, then you can plausibly see the system of the rule of law function. So what I mean by that is, let's say that we have the COVID emergency, and according to our domestic laws, in a case of an emergency, the executive has the power to enact any action according to their discretion to tackle that emergency, subject to a declaration of a state of emergency for, let's say, a month, right? That has a limited duration. Now, let's say that the president, in that scenario, acts in ways beyond the power given to them by that provision. The rule of law, in my view, can only be seen as surviving the emergency if, subject to the termination of that emergency, you are able to hold the executive agent accountable for their ultra-virus action, whatever that might be, if they acted beyond the discretion that was provided to them according to the law. So I think that's the key point there. If there is accountability, then it's plausible to see the rule of law as existing even in times of emergency, because executive actions are subject to powers granted by legislation, instead of simply haphazard actions by a person in power, if that makes sense.
Mm-hmm. Yeah, no, it makes sense. But I mean, when I say violation of the rule of law, so I guess in your example, how are executive powers given? Isn't it somewhere written in a constitution or somewhere in a law? So
exactly.
If it's in a constitution, that means that it falls within the rule of law. It's not an ultra vires action.
Exactly, but if the exercise of that power is beyond that provided by the legislation, then it immediately becomes ultra vires and therefore subject to ordinary rule of law responses, whatever those might be.
Yes, no, exactly. I think the point is not the point, but I think a good consideration is what kind of consequences occur when you try and justify violations or suspensions of specific European values. So I'm not saying that violating fundamental rights is good or fine, or violating EU citizenship is okay, and imposing measures that restrict it. But it's how you define the rule of law and how much importance you attach to it, and how, I mean, what other branches or what other aspects it would affect if you justify such a suspension. If that makes sense, what I'm trying to say.
I think it does, yes. Nadia?
In this discussion, I realized though that we come from two very, as I said to my previous colleague, from two very different perspectives, because it comes down to, within the European Union, you have the ECJ, which you expect is going to put a boundary, which we not, as we heard earlier today. This in itself is problematic. Within a country, we usually have the highest court of the country who is expected to again draw a boundary to exploiting, to going ultra-vires. But in the Cypriot example, we have what we were discussing during the lunch break, the never-ending application of the doctrine of necessity. And then I also, in the terms of the discussion, I remembered when I was doing another research on emergencies in international law, that they were looking at emergencies, countries that are functioning under an emergency, and you have Israel, which is in an emergency since 1948. This was declared from then until now. This has been acknowledged on 2 or 3 occasions within the UN, and now it's the norm.
Yes.
So how do you put at the end on, maybe it is the fact that all these different institutions, like the EU as an EU law as an institution, international law as an institution, domestic law as an institution, they function differently. In which case, maybe we need to start discussing the issue in 3 different strands, acknowledging that they are quite fundamentally different, and we're talking about different rules of laws, which goes back to what we were discussing in the morning. Or we need to actually be ready to accept that the rule of law is highly problematic, and that is a vicious cycle, that it can always justify things that shouldn't be justified.
Can you step in here, Andrea, when you finish?
Yes, please. I had a feeling you were going to jump in.
Yeah, please enlighten.
Okay, well, what I would say, I would put forward the following proposition: that the pandemic, or perhaps more accurately, the state response to the pandemic across the UK and the European Union, demonstrated how inherently vulnerable democracy and the rule of law are. I will just make 3 points in support of that proposition. Firstly, some governments, particularly the UK government and the state government of New York, albeit obviously on the other side of the Atlantic, together with a number of other governments, failed at the very outset of the pandemic to protect the most vulnerable people in our society, namely the residents of care homes. And one reason there was that panic in March and April of 2020 was because, by the evidence that has since emerged, vast numbers of people who died in that period were actually elderly and vulnerable people in care homes who were not protected in the way that they should have done. Secondly, as the pandemic unfolded, I have to say, the so-called vaccines were introduced. I say so-called because these were not traditional vaccines which gave you a dose of the illness that the vaccine was designed to protect you. The so-called vaccines were introduced, and the basic medical principle of informed consent appears to have been cast aside across the United Kingdom and the European Union. In other words, people were queuing up to be vaccinated, in inverted commas, without giving free and informed consent in line with the most fundamental of principles to do with medical law and medical ethics. And the third thing that I'll say in support of my proposition is that in relation to both the pandemic and the response to the pandemic, it became all too easy for governments to introduce draconian restrictions on freedom that we had never seen before, at least not since the Second World War. And what was troubling during the pandemic was the collective acceptance of these draconian measures, and also what amounted to the bullying of those who were standing up to those measures. So what I would do in closing would be to suggest to you that the pandemic, and to be more exact, the reaction to the pandemic, demonstrated the inherent vulnerability of the rule of law in any democratic or so-called democratic society, such as the ones we have in the United Kingdom and the European Union. And that's a matter of acute concern for all of us who care about democracy, freedom, the rule of law, and other fundamental humane values.
Okay. Would someone like to respond to that? Because Claire, I think I agree with your conclusion and your first premise. I disagree with the second, and I partly agree with the third. So let me elaborate. I first of all agree with your assessment that democracy and the rule of law, or better yet, that the pandemic has showcased or revealed problems in terms of safeguarding democracy and the rule of law. I agree with that assessment. I also agree with your first premise about the inadequate initial response, so I have no problem with that. I disagree with the second one in terms of informed consent. As long as the vaccine was not legally mandatory, there was always the option to refuse. So if someone agreed to be vaccinated, then they consented. And in my view, it's no different from what happens in ordinary medical procedures, right? You go to the doctor, they tell you, you need to do this surgery, and you subscribe to their authority. In most cases, you say, okay, I'm going to do that, and then you proceed with the surgery. Of course, you don't have a medical degree, you don't have the relevant medical expertise. So what you do is reasonably accept someone else's authority in that respect. With regards to the third point you made, in terms of proportionality, I do agree with you that in many cases the measures were disproportionate. I would say, however, that there have been responses to it, right? Whether you agree with those responses or not, it's a different question, because we have seen, maybe not so much in Cyprus, but in other countries, we have seen on occasion quite robust response in terms of rejecting government mandates. Again, I'm not condoning that, I'm just saying that it was something that happened during the pandemic, that you did have actually social action and protest and movements and all that. And you also had a bunch of legal cases that in many European countries successfully challenged measures taken by the government. I don't know if you'd like to respond to any of that, Claire, or if anyone has anything else they'd like to put forward or discuss in that respect in the case of emergencies. Let me also point out here that one worrying tendency is one noted in countries run by populist regimes such as Hungary, which in those cases we did have the government talking about the pandemic, taking action against the pandemic, but that action was clearly disproportionate. It empowered, it centralized government power, gave the government extensive, disproportionate power to tackle the pandemic, without time constraints, of course. And we ended up with legislation that, for instance, criminalized any speech that contradicted the government's message about COVID-19. And this kind of legislation is, of course, clearly undemocratic and disproportionate because it was weaponized to target opposition parties and dissenters and so forth. So I think that Claire is absolutely right to point out that emergency actions could have a spillover effect, an effect that stays with us even beyond the COVID-19 pandemic. Is there something anyone would like to say in that respect?
I'll just say one last thing, Andreas, because we had to go to another meeting at 4. In the United Kingdom, as far as I'm aware, no formal state of emergency was declared.
You're absolutely right, yes.
Indeed, the legislation that was used was not the emergency legislation set out in one of the Acts of Parliament that the Tony Blair administration introduced, but the Public Health Act of 1984. So it was there was no formal declaration of a state of emergency, and nor was there any exploitation of the state of emergency legislation that's on the statute book. And as far as I'm aware, even though the President of the Republic used the word emergency at the start of the pandemic, he did not formally declare the state of emergency. And that, of course, raises all sorts of questions. But as far as we're concerned, this highlights the importance of clarity during any crisis, because there was unnecessary confusion, I recall, at the start of the pandemic in the Republic of Cyprus, when the president used the word emergency, but didn't go one step further and declare a state of emergency. I'm not saying he should have done, but why did he sow that confusion by his use of that word? And he was a lawyer, so he should have known better. So yes. Politicians, another lesson of the pandemic is that politicians need to be careful about the words that they use whenever they're handling any crisis.
Yeah, and I think you're absolutely right. And, you know, there's much scholarly work out there talking about how it would have been better had cases of emergency been declared, both in the UK that you mentioned and in other countries, right? I don't know if that would have been a better approach, but there's much work being done saying that it should have been the case, precisely because of the reasons you mentioned earlier, right? That even though an emergency was not declared, in the UK, there was inadequate action and there was much confusing legislation. I mean, remember, was it the rule of 6? Was it in the UK? Wasn't it, Marcou?
I think it was the rule of... It was baffling to understand some of the legislation.
Yes, exactly. For a time there was a rule of 6, and then it was, a little bit crazy. Nadia?
I just wanted to add to that, though, that this is hardly surprising that an emergency was not declared in many countries. I mean, comparative case studies have shown that very often, because of the limitations, because the constitutional procedures are there to make the politicians accountable for the decisions during emergency, because these are powers of surveillance by default, right? So, but they are only triggered with a formal declaration. So if there is no formal declaration, the mechanism to make them accountable for the decisions taken is not triggered. So this is why earlier I insisted on the political interest in declaring an emergency or not, on following the legal path or not. And it was already in 1988 when the International Law Association made an international study on that, and they identified a number of emergencies, and I think 4 scenarios that are usually applicable. The one is what they call the classical emergency, where you have an emergency, you declare an emergency, and you are therefore accountable within the framework of your constitution. But the other one, which is becoming more and more often met in practice, is the de facto emergency, whereby in the circumstances you know there is an emergency, but the executive will fail to declare it, so they are not accountable. And by this, I don't mean only conflict, but it takes into account environmental, natural disasters, famines, pandemics, for that matter nowadays, and so on. So this is why these different dimensions are actually all relevant to discussing emergencies. And one of the good things about the pandemic in that regard has been that more or less, if we put put aside the fact that not all countries have equal access to medication, the disease and the health issues at the rift of the pandemic are actually one of the very few examples, if not the only one in the last decades, where it equally affected all countries. So it made it even easier to draw such comparative conclusions.
And even within countries across classes.
Bravo, exactly. Yeah. Yes.
Okay, well, with that, I think we can move. We've talked about that. So that's wrong. I have no idea what's going on. In any case, okay, we don't need the slideshow. The last point that I wanted to raise, and I think it's a nice concluding thought for this session, is what can the European Union do about the rule of law if indeed there is this sort of problem in terms of the rule of law? Now, there are some things that the European Union can do that they haven't utilized yet, and others that they cannot utilize for different reasons. We could divide them into two categories. So we could talk about hard law, legal mechanism, and soft law, non-legal mechanism. What they have done is they have used against Hungary and Poland as the main culprits of rule of law violations. They have used infringement proceedings, for instance, bringing action against Hungary and Poland. Of course, we can debate how effective that was, in the sense that it hasn't really changed much of what's taking place in Hungary and Poland. And then the other legal mechanism is the Article 7 procedure, whereby if it is found that there is this clear and serious breach of Article 2, this could eventually, down the line, lead to political sanctions that can be quite severe, right? Taking away a country's vote in the council and so forth. That mechanism has been enacted, it has been initiated, let's say, against both Hungary and Poland, but it hasn't resulted in anything because it, among other things, requires unanimity in the council, which of course could never be achieved as long as you have multiple culprits. So as long as you have both Hungary and Poland, for instance, having a council vote, then the Article 7 action cannot be realized. A third legal mechanism is the rule of law conditionality regulation. This is the latest tool that the European Union has created to tackle the rule of law backsliding. It hasn't been used so far. So this regulation essentially, and I'm simplifying here, essentially says that if a country does not meet their rule of law obligations, they don't maintain the level of the rule of law required, they are not going to receive funding from the European Union. So withholding funds because of those violations of the rule of law. Recently, and when I say recently, I mean probably 6 months ago, no, 4 months ago, in January, the Court of Justice decided that this regulation was constitutional. It wasn't contrary to the treaties and can be used. It hasn't been used yet. The regulation can be used, can be launched by the Commission, and the Commission has not taken action in that respect yet. We can speculate why that has been, right? The political reasons why the Commission has not opted to do that. That hasn't stopped the European Parliament from essentially bringing an action against the Commission for their failure to use that mechanism. Now, when we move to soft law, non-legal mechanism, the latest one and the one attracting most attention now is what I mentioned earlier, the annual rule of law report, which has a different chapter for each member state, assessing the state of the rule of law essentially, on a basis of multiple markers. what I think this discussion shows us is that the European Union has not been able to safeguard Article 2 values. It has not been able to use its legal structure in a way that limits their violation, and it has not been able to safeguard the rule of law. Now, we can speculate why that is, and indeed, Dimitri's speech earlier did point to some possible reasons for that failure. But I think it's important to point out that there are many political reasons why the European Union has been reluctant to do things about the rule of law threats in its territory that have essentially tied the hands of different actors and institutions within the European Union that might have been willing to do that. And this has in turn emboldened countries like Hungary and Poland to continue with that recalcitrant behavior, acting in ways that might permanently damage the state of the rule of law in the Union. So I don't know if anyone has anything that they'd like to say in that respect, any comments that you have, any suggestions you might have, any criticism you might have, or anything that you'd like to comment about the state of the rule of law in the European Union, or the state of the rule of law globally, or the position of the European Union and so forth. Yeah, please, Evelina.
I just imagine the situation. How to realize the rule of law in the vessel when you have one captain and a team, and for instance happened a crime. How the rule of law will be realized? We have the only person, captain, and he will judge.
Mm-hmm.
So, and how to check if it was the rule of law or it was the rule of captain?
So in that case, it will be the rule of law. It will simply be the rule of.
And the same is in can be in the states that have the authoritarian power, as we had previously, for instance, 70, 80 years ago, while the period of repression. So from one side, we saw the rule of law. Because they were judges and they quickly had the session and verdict people to death penalty and so on because they were traitors, for instance. So from one side it was a picture that it is a rule of law because a person was not killed just because someone won. There was a court, there was a jury, yes, and they decided that he is guilty. So the problem was that the state was not democratic. But even if the state democratic, always depends on the person. And maybe Hungarians, they are happy with their model of rule of law. Because they are happy in their life is okay and their justice is okay. They are happy with it. So if we are judging how the quality of the rule of law, we need to see other people satisfied with it. And to check it, it is possible only if states have democratic and open relations. And European Union has the instrument to check it. To apply to people, are you satisfied with this system? So it's not only the election that prove really this country has a rule of law. Because we 30 years go to elections and we cannot vote for appropriate president because first of all the commercial elite, they suggest some personalities, but it's not the political parties anymore. It's just the political entities that we have in Ukraine. You know, maybe in Europe we do not have, but in such countries like we, Ukraine and Russia, we still have this. In Belarus, they do not have choice. We have choice, but it's how to choose the worst, not the best. Yes, not the best. This is
and I think
what is the instrument? Everyone who goes into power must understand how he will answer not to his people, but also to the international arena. If he really is guarantees fulfilling the rule of law. So my remark.
No, and I think that, Lina, what you're pointing at here is the distinction between rule of law and rule by law.
Yeah,
right?
rule by law.
So regimes historically have used law to rule. That doesn't make them rule of law systems, right? To have, as you pointed out, right, a judge give an answer to a case before them doesn't necessarily make it a rule of law system, because you need to look at the context and the character of the system, or what I call the legitimacy of the system overall, in order to make an assessment whether it's actually a rule of law system. So I think that's a very poignant.
And we need to bring up a person from the really childhood who has to understand his duties also and his rights from the very childhood, not to grow up a person who has restricted access to the democracy.
And also the importance
and
of
this is
civic
knowledge.
education. Yes.
Civic education.
We don't have any.
Yes. Tell us about the.
I'm sure you would have pleasure.
The mess on.
Okay, we have one comment from Dinesh. It says, as to India's position over emergency justifications for suspending the rule of law, they were quite conflicting. The imposition of emergency power rests with the center, and the state, for instance, doesn't have such power. Still, India got a typical kind of medical emergency enforced, which was not in actuality as the government, as at the central level, I assume, means doesn't issue any such notification or enforce any will. So again, not a declaration of a case of emergency. Instead, relying much on state provinces, which impose restrictions under general laws available in criminal codes and different acts already existing. Rights were curtailed, as was the case everywhere around the world. And the court failed in many respects, he points out, to protect those rights. Again, this sounds similar to the European experience. In the context of the European rule of law, it's quite interesting as it actually lacks in existence in EU models, except found in some remarks in various institutional organs. Again, that, in my view, boils down to different approaches to the rule of law. And it's clearly part of the treaties, right? So Article 2 does mention explicitly the rule of law, although you're absolutely right, doesn't necessarily come up in all different discussions at the European level. The European rule of law has been actually derived from German, English, and French ideas of the rule of law by constitutional when incorporated the same in new Eastern European nations into EU. So I think, Dinesh, that last point points to the first discussion we had about conceptualizing and understanding the rule of law. Because a typical argument made by Eastern countries like Poland and Hungary is, for example, that, oh, we have our own conception of the rule of law that is different from the Western conception of the rule of law. So you shouldn't be able to impose it on us. I'm actually working on an article now that suggests that there's a core part of the rule of law that remains the same no matter what account you're looking at. So in my view, that's simply a rhetorical device. It doesn't hold. So it doesn't mean that because there are different conceptions of the rule of law, of course there are, it doesn't mean that there's not some sort of common denominator or some common ideas that exist when we talk about the rule of law. And in my view, it's quite clear that when you take action, as that undertaken by a country like Poland, for instance, as Dimitri explained earlier in his lecture, it is beyond any measure of the rule of law. I don't think it's possible to look at that system and say, okay, this is a rule of law system.
Doesn't this core conception boil down to morality?
I don't think it should, because then you open the door to all sorts of different problems in that respect. If it boils down to morality, then you raise the question of what do you mean by morality in that respect, which leads to the greater question of what kind of moral philosophy do you assume that justifies that sort of morality. Whereas I think that even though the rule of law has, it might be a moral component, it's not necessarily reducible to that. Okay, is there anything anyone else would like to say as a final word? Well, thank you very much for sticking around to the end of the conference.